In this small lecture, I want to give you some material that's tangential to the course of human rights and human development. I will talk now a little bit more about the theory of international law and the soft law, hard law distinction. I will give you the message that this distinction is not a useful distinction in the field of human rights and human development, possibly also not useful in other fields, and that it makes sense to replace it with a better, more accurate conceptual framework. It's very common that my students in the course of human rights and human development experience frustration on the status of all the documents we read, because pretty much 80% or more of these documents are soft law. And then it's very easy for my students to say, well, this is after all soft law, it's not binding, and then more or less dismiss the significance of the normative documents. Now, the question about the legal status of these documents is a good question to ask at the beginning, but it's a question that we ask, we answer, and then set aside, because the issue of soft law, hard law is of very little importance and of very little relevance in the world of human rights and human development, and I would dare say it's every day less relevant in the modern manifestation of international law. The doctrine of sources of international law, which classifies some issues in being law, truly law, if they fall within the boundaries of treaties, customary law, and principle, and then something that is weak or not important, something that's less relevant, called soft law, if they do not fall within these parameters, is a relatively, I would say, a relatively outdated topic, a relatively outdated framework, one that whatever its merits, and it has merits, but whatever its merits, it's very hard to use to understand what's going on today. If you have that framework as your dominant frame, you will miss the importance, the real world importance of a lot of the normative production that we see nowadays. I suggest that we set aside the issue of hard law and soft law. What is the importance of hard law? Well, hard law is binding. But in the world of international law, binding is not a meaningful or important concept. Think about it this way. In the world of domestic law, if something is binding, what does that mean? That means it must be taken seriously, because if you breach a binding rule in the domestic sphere, there is going to be an apparatus of enforcement, of professional enforcers ranging from police to judges to bailiffs to prison guards that are going to ensure that you do what you are supposed to do. In international law, this apparatus does not exist. There are some strong enforcement mechanisms occasionally, but they only trigger in very specific circumstances. Thinking here now of something like Security Council enforcement powers. So then we do not have real enforceability, not enforceability of this sort, professionalized enforceability by professional enforcers, police, judges, bailiffs, prison security guards, and so forth. We don't have that. Then absent such enforceability, binding is just a word. Maybe it's a powerful word, and you say, hey, you breached a binding rule of international law. Okay, fine, it's a powerful word, but it's just a word, and other words are also powerful. You could say, well, you breached a binding rule of international law, that's my accusation, but maybe you could also say you breached the goals that the world community has agreed to meet. Okay, that's also a powerful accusation. Other words are also powerful. And then there is something to be gained by moving beyond the binding, non-binding dichotomy and then assessing the influence of a particular international norm on a more flexible and case-by-case basis without being constrained by the issue of binding, non-binding. Here, what we need to think of is gradual theories of international law. There's two theories that are notable here. One is the theory of Thomas Frank, a very influential writer, and the theory of Anthony Clark Arendt, a less influential writer, but one that in my point of view has clearly improved on the work of Thomas Frank. But then what is a gradual theory of law or a gradual concept of law? Well, a gradual theory of law is one that does not ask the question, is this law or not? Is this hard law or then not law or soft law? It asks a different question. It asks, how much law is this? And note that this question is non-idiomatic. It doesn't fit the way we use language. Okay, that's fine, but still it's a theory that will really give you insights, whereas the other theory will most probably not. And then the idea is that something can be more of a law or less of a law depending on how it performs under certain parameters. For example, in the case of Thomas Frank, what he says essentially, what makes international law matters, absent any sort of real mechanism of enforceability, is their legitimacy. Legitimacy is the lifeblood of international laws. And then he says, well, the more legitimate a norm is, the more it's perceived as legitimacy, the more it is an international law. If it's less legitimate, then it's less of a law to the point that it's no law at all. And then you may see that the classic sources of international law do play a role here, in a sense, because a treaty will have perceived legitimacy, a custom will have perceived legitimacy, and that's fine. But the other manifestations of international normative production would also play a role. And then you could have something like the Millennium Development Goals or the Sustainable Development Goals scoring very high in the level of perceived legitimacy without being protected by any formal source of international law. And then according to the theory of Thomas Frank, they would count very highly as being more law than other things. In the case of Anthony Arendt, he makes the theory more complicated. He has a two-factor model. So he says, well, you have legitimacy and enforceability. Now, when you have a real rule of international law, you have a rule that's very legitimate and that's also very enforceable. That would be more law. Less law would be something that has very high legitimacy but low enforceability, or something that has high enforceability but low legitimacy. And something that would virtually not be law at all will be something with very low legitimacy and very low enforceability. From that, taking these authors as a basis, you could even go into multi-factor models. So what makes an international rule be more law than other putative international laws? Well, you could say its legitimacy, its enforceability. You could factor the having binding status under the Vienna Convention of the Law of Treaties. But why not other considerations? For example, the clarity of the rule, seeing a more clear rule is more likely to be regarded as legal, or will be regarded as more legal than a less clear rule. Another one may be a stakeholder support. To what extent is this putative rule supported by various stakeholders from different countries and different lines of influence? And then here we have a little bit of a graph of Arendt's model. Now, as I said, the model can be more complicated, as in the multi-factor model, it could be less complicated. But there you see this radical way of thinking. You see that, that instead of asking a question in a binary fashion, is this law or not, we ask a more complicated question. We ask, is this more law or less law than the alternative? So we're looking a bit to this a little bit in a more comparative fashion. And then we try to see not just whether something counts as a rule of international law because of the satisfaction of preconceived categories of what counts as a binding rule and what does not, but rather we look more carefully and say, okay, what is the perceived legitimacy of the Millennium Development Goals or of the Sustainable Development Goals? Well, I would put it pretty much way up here. Now, that is a global project that enlists support of pretty much all of the international community. And how enforceable are these Sustainable Development Goals? Well, to be honest, I would go for something here or even a little bit more to this side. So we make the lines meet and, oh, well, that's a pretty bad line, but you get the idea. Then you see the Sustainable Development Goals rank pretty highly here. Now, then let's compare them in this multi-factor model with something that clearly is binding law, but may not do so well. Let's talk about the ICESCR, the International Covenant on Economic, Social, and Cultural Rights. How legitimate is the ICESCR? Well, it's pretty legitimate. It's a treaty, but it's not the darling of a lot of countries of the world. So a lot of countries do support the ICESCR, but developed countries do not see it as the most important or the most significant human rights treaty. They do not see it as especially useful in comparison to other instruments like the MDGs and the SDGs. So while it has legitimacy, I would clearly rank the ICESCR below the MDGs and SDGs. And what about enforceability? Is the ICESCR easy to enforce? Well, compared to the MDGs and SDGs, the answer is it's much less enforceable. Because even though it has these binding rights, the rights in the ICESCR are very vague when compared to the specific indicators of the MDGs and SDGs. There is no real court. You have the Committee on Economic, Social, and Cultural Rights that has some enforcement powers as far as goes as answering individual complaints, but I would not consider that to be very strong at all. I would put it way behind the MDGs and SDGs in their enforceability. So let's be a little bit polemic then. And then I would say under Arendt's model, we would, and I think this is a very interesting point. If we just say, oh, the ICESCR is binding law and the MDGs, SDGs are not, we're losing a lot of information. We're not seeing the bigger picture. That is a way of thinking that may have worked at some point, but now it's less interesting or less useful. If we see their actual qualities in terms of legitimacy and enforceability, we may see that counterintuitively, but with good backing, the MDGs and SDGs score much better than the ICESCR. I want to end presenting a caveat. Of course, officials, judges, diplomats, and the lawyers that work with them will not recognize, they will not accept the gradual theory of international law. They will still say that hard law is what matters, that soft law maybe it's important, but it's categorically less important, and that some things are law and some things are not. This is to be expected, but we must, as academics, and here as students you play the role of academics, we must look beyond the appearances and try to understand what really works and what really matters. Of course, I would say also as a practitioner, maybe the discourse that surrounds you will force you to talk in a certain way, but a good practitioner, a good diplomat, a good judge knows what's going on. And knowing what's going on, again, is trying to look beyond the appearances. So I think this is in basically a superior model to understand the world as it looks right now, and I present it for your consideration.